Welcome to a fern between two Burks.
What's a Burke?
A right Burke. An idiot.
I don't get it.
Hello and welcome to Legal Beagles Christmas special for 2019. I am Alex.
And I'm
This
Cal.
is Callum.
Were you always dressed like that?
Only for special occasions. I'm sure you've noticed. And today we'll be counting down our top 10 picks for dismissals of the year, where we will be taking a walk of fame and indeed a walk of shame through the highs and lows of the Fair Work Commission of 2019. Kicking off our list at number 10 is the relatively recent case here in Brisbane of the Audi worker who was dismissed for being in the lower percentiles of his cohort in terms of performance. Now, this is an object lesson in that just because someone is not performing as well as others does not mean they are not performing their job properly. Now, in this case, yes, he was in the bottom percentile, but he was still hitting all his KPIs. When he went for unfair dismissal before the Fair Work Commission held that him being in the bottom half of performers was not a valid reason in all of the circumstances to justify dismissal, and he therefore won his case and was awarded compensation.
Next on our list is a case that really demonstrates why you don't mix business and pleasure. A family smashed repair company where the son showed up late for Sunday dinner. Right there on the spot, he was sacked. I guess that family dinner was a bit of a car crash, bit of a train wreck. He took his parents to the Fair Work Commission and was awarded $10,000 in compensation. The family didn't even show up at the hearing before Commissioner McKinnon. Now, Commissioner McKinnon did express some disappointment about the breakdown in relationship, but she still found that he had a right to file for unfair dismissal.
Taking our number 8 spot in this list is one of the more bizarre dismissals ever to darken the Commission's doorstep. This case involved an electrician who described himself as a Nazi Sparky and a holocausting machine, who engaged an apprentice with the contractual provision that if you don't like your wage, you can f*** off. Now, clearly, we can see where this is going. Now, this Sparky employed an apprentice, as we've mentioned. This apprentice did a cash job for a former employee of the business. Now, this former employee was on very bad terms with the Nazi Sparky. The Nazi Sparky wanted the address of this former employee so that he could, in his own words, go with him. The apprentice refused to provide this information and was told that if he did not provide that information, he would be considered to have voluntarily resigned his employment. The electrician took a principled stand, saying that this was not a lawful and reasonable direction, and was consequently told that he had voluntarily left his employment. Deputy President Asbury held that this was not how employment law works. Rather, the absolutely outrageous behaviour of the Nazi Sparky by sending multiple threats to the apprentice by text message in the lead up to this circumstance resulted in the repudiation of the employment contract which the employee was entitled to accept. Now, Deputy President Asbury was perplexed in this case as she felt that the outrageous behaviour of the Sparky required a higher level of compensation, but had to bear in mind that she could only compensate for loss of income. And given the depravity of the Sparky's behaviour, could not see the apprentice lasting for much longer than he had, and so awarded $11,400 compensation.
Next on our list is a case that really demonstrates the importance of monitoring risks to health and safety. One employee in the Australian Capital Territory, so he would have something to talk about with his colleagues, decided to bring in inert explosives into work and rolled one underneath one of his colleagues' chairs as a joke.
I can appreciate the sentiment.
The employee was, of course, dismissed following this conduct and appealed his dismissal to the Fair Work Commission. On first instance, the Fair Work Commission held that even though none of his colleagues were alarmed by this conduct, nonetheless, other employees might have been. Even though the explosives may have been inert, there was still a risk to psychological health in this case. The employee appealed that decision to the full bench this year, and the full bench found that there was no issue with the Commissioner's or the Deputy President's interpretation on first instance. It just goes to show it wasn't such an explosive situation after all.
Please don't. Reaching the halfway mark at number 6?
6 is not the halfway mark. 5 is the halfway mark.
Really?
Yeah, 100%. 100%. Where's the support?
Yeah, it's taking us into the halfway mark.
No.
Pedantry, sophistry, welcome to lawyers.
All right.
Number 6 on our list is a case which emphasises that care must be taken when dismissing an employee for out-of-hours conduct. Now, in this case, an employee of a contractor to the Sydney Opera House had a few drinks after work at the Opera House bar to farewell a colleague. Now, they had a little bit too much to drink and ended up vomiting over the floor and had to be escorted into a cab. Allegations were also made that they had made some comments which could be considered sexually harassing. Now, their employer, the contracting company, determined that these allegations were proven and dismissed the employee for them, and also dismissed the employee by relying on the notion that their conduct in the Opera House bar could have negatively affected the company's relationship with the Opera House, their clients. Now, the Fair Work Commission disagreed on all counts, although the Commission agreed that if the conduct was so severe that it could have negatively affected the relationship with the client, it determined on the facts of the case it was not so severe. Indeed, the Commission said that if every inoffensive act of drunkenness resulted in dismissal, most people in Australia would be without a job.
Next on our list is a casual sales assistant who held a job at the same grocers for 20 years. When new management came in, she found herself quickly in a position where her shifts were being given to other employees. She applied to the Fair Work Commission saying she'd been unfairly dismissed. Interestingly, in this case, Deputy President Sams exercised his discretion to conduct inquiries, went onto a Chinese-Australian job board and found out that the employer had put up ads specifically seeking people from overseas backgrounds. As such, the Deputy President found that this employee had been discriminated against and had been dismissed unfairly. The Deputy President also referred the matter to the General Manager of the Fair Work Commission to decide if it should be referred to the appropriate authorities for unlawful discrimination.
The next entry on our list is an object lesson in the use of social media in the workplace. Now, in this case, the ownership of the business had changed from South Australian owners to Victorian owners, and this had caused a cultural shift, which in turn was felt in the workplace. Following the death of a co-worker, the employee in question suffered a bit of an emotional breakdown, which led to her putting an emotional rant on Facebook about her new employers. This was held to be a valid reason for dismissal, but the employer lost the case for procedural reasons, not least of which was the fact that the employee was in a highly emotional state and had a mental health condition that needed to be taken into account.
We're now into the top 3 dismissals of 2019. Topping off the list at number 3 is a case which we talked about way back in episode 1 of Legal Beagles, Mr. Jeremy Lee in Superior Wood. If you want the full details of that case, you can check out our first episode. The reason why it's made our list today is that it's not over yet. Mr. Lee successfully won his appeal in the full bench of the Fair Work Commission, which confirmed that an employee has the right to refuse to provide their biometric data to their employer. However, Mr. Lee wasn't happy with that decision. Even though he won, he's taken the full bench of the Fair Work Commission and each member on that bench to the federal court. What he's after exactly, we have no idea.
Some people are never satisfied. Taking the penultimate spot on our list is probably one of the darker cases to come through the Commission this year. In this case, the employee took 3 days approved paid sick leave to undertake chemotherapy treatments. Their employer tried to contact them on the last day of this leave, but was unsuccessful. Consequently, the employer told the employee that they considered that they had abandoned their employment and were dismissed. Now, obviously, this was going to go fairly poorly for the employer, who nevertheless tried to defend the case and took it all the way to a final hearing. The Commission held that this was probably the most heartless case that they had ever encountered. the employee was on approved sick leave, they were under no obligation to answer their phone when they were probably in no fit state to do anything, being weakened as they were by chemotherapy that they were undertaking. And the circumstances in no way amounted to abandonment of employment. Obviously, reinstatement in this circumstance was not appropriate and the employee was awarded compensation, but the employer was roundly criticised for their incredibly harsh and ruthless approach to employment.
Before we round the list off with our number one pick, time for some honourable mentions. First up was the Pelican feeder, who had one shift a week for $30. He was dismissed after his employer wasn't happy with his responses in failing to disclose some financial figures. He was reinstated by the Fair Work Commission and is now back to feeding pelicans for $30 a week.
The other dismissal that we would like to make honourable mention
What do
of...
you mean other dismissal? There was only one on.
Yours. You're fired. There's the door.
See you in the Fair Work Commission.
I look forward to it.
Now, Alex, we've come to our top pick, but I must ask you, is there anyone we're missing? I feel like we've got them all.
Well, obviously, there is one dismissal in particular that has caused more media, political, and public interest than any other that has come across the airwaves.
No, we've
this
spoken
year.
about the Pelican feeder.
I'm, of course, talking about the matter of Mr. Israel Folau.
Mr. Folau, of course. How could we forget Israel Folau? Taking out our number one pick for the top 10 dismissals in 2019 is Israel Folau and his quite high-profile separation from Rugby Australia earlier this year.
Now, obviously, this case has generated a significant amount of interest, both in employment law circles, in political circles, and indeed it has spurred the introduction of legislation, and among the general public, as to the question of where does the freedom of religious expression end and the right of the employer to regulate that religious expression begin. The question has yet to be answered.
Now, Alex, obviously we haven't seen all the material that's been filed on the case, and both sides are represented by some very preeminent legal practitioners. But today, if you had to put a bet down on where you think the court's going to come down?
Well, given how Mr. Folau has continued to engage in the conduct complained of, for today, I'm not entirely sure I can make a bet. It would depend on what he does from here on out.
Yeah, I think we're going to get some real clarity after the decision comes out, which is not expected until sometime before mid-next year.
Oh, probably later than that.
And that concludes our top 10 dismissals of 2019. Let us know how you think our list stacks up, if we've missed anything that you would have liked to see added. And of course, have a fantastic holidays, and we'll see you in the new year.
Well, one of us will.